Very excited to be here for the second episode of this quote unquote podcast. And the first podcast ended up being, by our terms and metrics, a fantastic success. I am so grateful for anybody that listened to it on whatever channel or whatever medium. And so the second podcast begins now, and we are joined by partner at Zayed Law Offices, a great friend of mine. This man is, like basically a brother to me, Julian Hoshell. So Julian, welcome and thank you for agreeing to speak with me.
Thank you for having me.
So you and I have known each other for how long now?
Since 2013, so 13 years if I did math correctly.
There's some lore about how you came to join the office, right?
Yeah.
This, for people familiar with law hiring, a lot of lawyers go to law school and then they do some recruiting or they get recruited. They maybe go do a 1L, 2L summer with some law firm, find another job here or there. We have a different origin story for you, right?
That's right.
Okay, so maybe you can tell us about it. This is some lore in the office. Maybe we can share.
Sure. So I found you when I was a senior. I was at St. Francis here in Joliet. And basically I found you through like a Facebook ad. I think you were giving away like Bears tickets or something like that. And so I decided to reach out to you, and I was like, okay, maybe he can let me work for him or something like that. I was trying to figure out if law was even something I wanted to do, so I felt like getting experience would help make that determination for me. And so I reached out to you, and basically, every time I reached out to you, I was told that you were in a meeting or something like that, and so I just kept calling you and sending messages to your office for, I don't know, I want to say it was a couple weeks. You could correct me if I'm wrong. And at some point, you allowed me to come in and speak with you, and the rest is history.
Yeah, so that would have been April 2013.
Just about, yeah.
At that point, the firm was not yet 4 years old.
Correct.
And I remember that incident well. We've talked about it. Julian came in for his initial interview at the office. You mind if I say this?
Yeah, sure.
he was wearing a suit. Credit to this man. He was very young. So you would have been like 22.
Yeah, right.
You had a pair of suit pants and you had a blazer that did not match very
Whatever
well.
I could pull out.
I recall that. And then when I talked to you and we had a nice conversation about what you wanted to do, there was one particular factor that struck me, and I said, well, do you have an interest in trial law or being a personal injury lawyer? You're like, no, I think I'm interested in divorce law, right?
Yeah, it was more geared towards that comment was more geared towards like children and always wanting to help kids and things like that. So it didn't necessarily impact my ability to want to learn about the law in general. But yes, that is accurate.
So now we're 13 years in. You have you've basically grown up as a man during your time in the law firm. I mean, you have had tremendous personal milestones. You got married. You have some beautiful children. You've developed in, so many ways, and you've done so tremendously. And your practice of the law has, your sophistication and the rigor and the depth and the specialization that you've acquired is profound. Like you have proven to be like extremely formidable in the things that you do. In particular, I mean, now we can talk about this journey. Now you are, I think you are just absolutely elite in terms of obtaining discovery, in medical malpractice cases, in terms of strategy for these medical malpractice cases, in terms of handling hearings on huge, mega, multi-million dollar, like affecting hearings, right? You are involved in basically every medical malpractice case in the firm, right?
Right.
And at this point, the firm has something like 100 medical malpractice cases, something like that.
Right.
I mean, we do a lot of other work. You do a lot of other work, but I think that your work on discovery on these issues is, it is elite.
Thank you.
And you've come a long way from that young man who came by in April 2013 with, looking for answers about where you're going to go with your career.
It's definitely been a long journey, but I would say, thank you for all the kind things you just said. But a lot of it has to do with the mentorship that you gave me. I remember you essentially training me from the ground up, and even redlining all the briefs and all the work that we did back in the day. Always trying to find like the right word, the right phrase, the right idea, and it's that chiseling or turning over every stone that's led to where we are today. Not only just with discovery and things like that, but how we approach cases, how we think about the law, how we think about our clients. So credit to you.
Well, I mean, Julian is a man with integrity that is off the charts. And, we started in a place where in 2013, that's when you started at the law firm. The cases we were handling back then were not quite as complex. I mean, maybe at that point we had 75 or 100 cases. And we had a lot of like important cases that were ongoing. We're grateful for every client we had even back then, but the law firm has just, it's been rapid, amazing growth, and the sophistication of what we're doing and what you're doing has, grown tremendously. Like I think it's on like national level. And, for us, I mean, we both are humble. We have a inherent humility,
Try to be, yeah.
But at the same time, what we are doing is, I mean, it's legitimate, I don't think it's really second to anyone. And, we've come a long way. It's a lot of belief in each other that has helped to manifest that. You know what I mean?
Absolutely.
And again, credit to Julian, because he and I worked together on many of the firm's most sizable and important cases. Not to say every case is not important, but I don't think that there's a $1 million plus award that this law firm has where you didn't have your hands on it to some degree, right?
Yeah.
So, I mean, what do you say to that?
I'm just thankful for the opportunity. And, I remember one thing I told you during that. It was like it wasn't even an interview. It was more like a conversation back in 2013, just getting to know one another. And one of the things I remember saying to you was, I will treat your law firm as if it was my own. And so that's an approach that I take forward with every case, every client, any opportunity that I'm given to help represent somebody. I keep that in mind, and I, want to make sure that flows through in the work that I do. And so that's, I would say, something that's happened over the course of the 13 years that we've been here.
I think that I remember those words. I remember you saying that. And you remain true to your word, Yeah. You bring tremendous drive. And, this is, I don't know how many young law students will end up listening to this podcast in the future, but you worked, and you still work. I still work.
Yeah.
You put the hours in. Like, you forged yourself into the craftsman of complex, contested, litigation discovery that you are. And, it is just commendable what you've done. And maybe you can talk about that a little bit. Maybe you could talk about what it took to do that.
Sure. Well, just on that, I mean, I think, one of the basic principles or I guess takeaways growing up prior to meeting you was, I did a lot of sports or, set a lot of goals. And it's the fact that if you're not working at it, someone else is going to be working harder than you. And it's like, you can't be complacent. You have to be able to drive to get what you want to succeed. And no one's just going to hand it to you either. So, I mean, we know that on all the discovery issues or things like that, the defense is not just going to turn over the most damning piece of evidence they have. They'll do everything possible to not do that. And so we have to continue to get crafty. We have to continue to know how to leverage the law in our favor and how to obtain the thing that's that's going to be most successful for the case and for the clients. And in terms of putting the hours in, I mean, it's something that you just have to do. It's what is that phrase? It's like master of none, expert in one, master of none, or being general in something doesn't allow you to become an expert in one thing. And I think if you focus on your craft on a particular set of skills, it allows you to really elevate yourself. And that's what I started noticing, especially on the med mals or the semi-truck crashes or whatever that we've been allowed to work on. We want to dig and get the best result for the client. That means we can't be complacent and mail it in, because then you're not going to get that ultimate result for them. And so that's kind of the drive behind it, whether it's discovery or writing the briefs, or at the end of the day, it's about getting the best result for the client. But they need that level of representation.
I like the phrase, jack of all trades, master of none. And I think that there are many firms out there, and my point here is not to disparage anyone, that do take anything that comes in the door, because, perhaps they've found a way to be profitable doing so. Yeah. And, it's perfectly reasonable for an attorney in a law firm with some enterprise to, represent clients well, but also try to be profitable. I think we've taken another approach, and I mentioned this before, and it's something that's always on the top of my mind. It translates to litigation, and it's about segment. There's a thing that happens to lawyers, and I'm not even saying it's a good thing, but as the complexity of the cases increase, that's where your drive and ambition goes. Like you're looking for that new challenge, that new interesting case that is going to capture your interest. And of course, the client's interests are always first, but we are looking for that. And this constant honing that you mentioned has resulted in us taking on more and more challenging cases. And that's what we do. That's what we love to do, probably more than anything, professionally. It is take on more and more challenging projects, more challenging cases, more challenging litigation. From a professional standpoint, I think that that's an aspirational thing. It's a nice, positive thing that we do. And that has resulted in you having a very specific skill set, right?
Yeah. And I would say, in addition to that, it's, we hone and we craft the skill set, but also the new challenging cases that you mentioned allow us to get new skills that maybe we didn't consider at the time, or it opens our eyes to a different part of how certain evidence can impact those cases. And we go learn how to be very good with that particular skill in order to leverage the facts for our clients. So it's always getting better. It's always getting better, not only for the firm, but also for our clients, and knowing that when they choose our law firm, they're getting the best.
I think that when we approach litigation, there's a lot of ways to approach it. When we approach working on our cases, there's a couple of traits that we bring to the table every time. One of them is we genuinely like doing this. And we've created a culture around this firm where, it's what we want to do. We want to be around people that feel the same way. We're interested in working on complex cases. We enjoy the challenge. It's fun, and we get to sleep pretty easy. We have responsibility, and that can be a heavy load. But in terms of the work we do and whether it's good or bad, I don't think we're conflicted. We're helping our clients. We are loyal to our clients. And that's one of the defining traits of all trial lawyers, which is, the good ones. They are, and we are, loyal to our clients. You know what I mean?
Absolutely.
And that's also what drives us. When we get into it's happened before. The facts are bad, or maybe the laws, challenging, presenting a challenge to us, or maybe we get into some kind of situation like that. We dig down. We fight for the client every time.
Well, like we were saying, you talked earlier about how putting in the hours to do the work, right? And so at the end of the day, what you're saying is, we fight for the clients, but we shoulder not only our own lives, but it's also part of us. We take on a part of them. And so it's not like, oh, I have to do this because it's my job. It's like, I have to do this because their life is in our hands. And so it's, whether it's staying up till midnight to finish a brief that's super important for the client's case or whatever, we do it because they're part of us and they trust us. And so we have to do the same and do the best that we can for them.
See, this is the professionalism that I think that, maybe the world is in need of right now, but, our industry always is in need of. Sometimes people lament younger folks coming in, where is the professionalism? And I think you described it very well. When we represent the estate of somebody that has passed away, we are carrying on that fight for the family and for that person who passed away. We, like you said, we carry them with us. They're almost like a family member, we're not going to let them down.
Absolutely.
And it is of course, obviously a huge privilege for us that we don't take for granted. And, it's just, we do everything we can to secure, remedy for the wrongs that happen to these people. It's, when you're in that spot where it's like, I'm tired and, I just want to go home or whatever, people have that type of day.
Yeah.
We're going to dig in. We're going to make that result happen. Right.
We do.
That's such a good topic, that you brought up. And maybe we can address this one, because this is one that I remember some of our early conversations when you first started with the law firm. There's to a neophyte or somebody that is very logically minded, you can look at litigation and think, okay, why do we have to go through all this fighting and all these depositions and all this discovery? And why do we need to go do all these hearings just so the defense or the hospital or the company will turn over those documents? Why do we have to do this? It's it grates on you. It's it doesn't make sense. It seems like a waste of effort. It's hey guys, don't you get it? Don't you know what's going on? Why don't you just compensate the client? That is it's like a kind of a interesting situation. Ultimately, it's a paradox. How do you deal with the challenge of, the question of why are you guys on the other side making me do all this?
Well, it's the insurance companies are not going to freely hand over money. They're a business. We know this, and a lot of it is getting around the concept in the first place of, well, the insurance company's here to help me, and most certainly I would say that's not true, at least insofar as insofar as our practice of the law and how we've interacted with the insurance company, how they interact with us. So we need to go and extract that. And most of the time, they're not going to turn over their best piece of evidence. We talked about that a little bit. So it's necessary, unless if you want to resolve the case for cheap and you don't want to get your full value, then certainly litigation is not your path. But in order to do what's best for our clients, litigation is a must. And we often discover in the course of litigation. I don't know if you've seen the TV show Suits. It's not. It's like a lawyer drama show.
I haven't seen it.
Yeah. Well, one of the episodes in there, young Mike Ross is trying to find some evidence, and Harvey would be you in this circumstance, and I'll pretend to be Mike for a second. But Harvey tells Mike, good, now they're not willing to turn it over. You press where it hurts. Now you know where to look. And so that is the key to discovery. In a sense, it's like they start leveraging objections or privileges, or they basically refusing adamantly not to turn over something. It's like, that's what you want, because that's going to help you in your case, more likely than not.
I'm thinking back to the larger cases that we've worked on over the last decade. And I mean, you must agree. I don't think we resolved a single one that was very significant pre-suit.
No.
And I don't think that we've resolved even one, unless it was like a policy limits for $1 million or something like that, where we knew there was no additional, an additional layer of insurance or anything like that.
Right.
I don't think we've resolved one that was very significant without going through multiple rounds of discovery. So, there's like the attorney adage of, I think this worked more like 30 years ago. I have this image in my mind of an older lawyer is telling a younger lawyer, hey, you have to work up the file. And what does that mean? Take a deposition, send out some interrogatories or something like that. And then maybe you can get 3X specials or something like that.
Yeah.
And that has not been the path that we deal with. It is like exponentially more challenging, more discovery process that's involved, more depth to the motion practice that's involved in order to extract this discovery. And I mean, maybe you can take it from here, but the point that I want to make is, if you don't do that, you are leaving a lot on the table for your client, right?
Yeah, absolutely. I mean, the case is going to suffer, and every case is similar insofar as you issue written discovery, and you get back your original set of responses, and so you have two choices. You can either just say, all right, well, I'll let them stand behind those objections and move on and take the dep, or you can say, hey, why did you do that? And go fight for it. And I can think of almost every case that has been significant value for us is there's something behind those objections that they don't want you to have, and so you have to go fight for it.
At this point, how many litigations, how many cases? I'm hesitant to use the word litigation, but how many serious cases have we worked on? It's in the hundreds.
Yeah.
And over the course of time, like a prefatory here, in terms of our interactions with the defense attorneys, we don't bear ill will to these people. Many of them, we have a positive, relationships with. These are largely very good people, right?
Agree.
But it's a challenging, and this is a phrase we use around the office, like litigation is the, most conflict, ridden, endeavor you can pretty much come up with aside from actual combat, right?
Yeah, that's probably
I
true.
mean, maybe politics or something, add a little humility here. But it's like, even when it's with an attorney who, maybe I should add this. With attorneys, we know it's usually, they know we're going to go fight for it. So maybe there's less of those initial, jabs that come at us. But when we first file that lawsuit and then we issue the discovery and then we get all those objections and then, the 201K session, which is 201K is, pursuant to Illinois Supreme Court rule, where it's requiring attorneys to meet and confer about discovery disputes. Are there discovery disputes? Yes, turns out there's discovery disputes on every case, or at least as far as we see it. And, then the jabs come in. And what do we hear? It's like, maybe you have some of your own anecdotes.
I mean, it's always like, it's irrelevant, it's, unduly burdensome.
Fishing expedition.
Fishing expedition. That's the best one, fishing expedition. Or,
You're
something.
Paranoid.
Something.
Tinfoil cap.
There's nothing there. And it's like, oh, well, we'll see.
There's nothing there.
Well,
how many times have you heard that?
Being, basically saying it's not going to lead to discoverable evidence.
It's irrelevant.
Right. That's what I meant to say. It's not like literally there's nothing, because there's obviously something there.
Yeah. And then what happens? Every
Yeah.
time, what happens?
I would say we're 99% of the time correct of what we were actually trying to find.
We find out, maybe we'll get a chance to talk about this case. We find out that the driver of the defense vehicle was
intoxicated or what have you.
And they were hiding the drug test.
Right.
Or maybe their training was inadequate and they kind of pulled the card for the training
Or
and made an objection.
Med mals, it could be statements from the doctor to the hospital or the employer or what have you regarding the surgery at issue, or it could be the credential file. It could be so many things.
Or maybe a physician modified the operative report or modified their record.
Right.
Or there's a policy right on point at some hospital, just a something that's going to catapult, just crater their case. And, okay, well, don't want to turn that policy over, right?
Yeah, getting hospital policies, that's my favorite one, because it's always just objection irrelevant, or we don't have a way to find what you're looking for.
Yeah, I love that one.
No table of contents, no indexes. Well, how do you guys keep track of what you have,
Well, I mean, okay, so the pattern is we have a case. Let's say it's a failure to diagnose case or a surgical error case, and we need to get the policies and procedures at the hospital and maybe the bylaws.
Right.
And, okay, the bylaws, if we really fight, maybe we'll get the bylaws, right? And then the policies and procedures, if they have a table of contents, then what we see is they'll send the table of contents over and then, okay, choose which ones you want.
Right.
So it's like a menu, but you don't really know what the content is. So that's one version of how things happen. The one that you just described it's always kind of funny. It's like the defense attorneys that we're working with will take a posture of, well, you want some policies, and the judge is forcing me to turn over policies because they won't turn them over unless a judge forces them, right?
Most of the time.
And then we get into a spot where the defense attorney, who was previously obfuscating as to the existence of the policies or the content of the policies or the titles of the policies, is told by the judge to turn the policies over, and the defense attorney comes to you and says, which policies do you want? And you're like...
that was the point of my original request, right?
Yeah.
Let me see what you have so I know what to get. And at the end of the day, we're not... a lot of the arguments I hear from the defense is you're chasing around things that are not relevant. It's well, if I had something that told me what you guys have, I could go enumerate what I'm looking for. Or half the time I hear, oh, are you looking for the bathroom policies? Well, obviously not, right? I'm obviously not looking for that. But it's kind of like a logical conundrum to say that you have all these policies, but I don't know what I actually have because I don't have any way to organize them, or it's...
Well, it begs a question in my mind of one, how can a hospital run if they have this array of policies that are constantly updated? They go through committees, but they don't know how to find them. So that's one point. The other point is, okay, analogy, it's kind of like going to a restaurant and you sit down and the waiter comes and says, well, what food do you want? And you're like, well, is this Italian restaurant, or is this you guys do burgers? What do you have on the menu? They're like, well, we can't tell you that.
Just tell me what you're looking for. I can tell you if I can get it for you or not.
Right.
It's like, well, yeah, it's definitely like that. Or it's usually asking us to limit what we're looking for without even knowing what exists. And that is a true detriment to not only the case, but the client, because you have to know. And so,
it's important to fight to get the information that we think could lead to relevant and admissible evidence, right?
absolutely.
And I mean, our philosophy on the spirit of the law, and we're open to, I don't think we're hardliners. It's just like we have a philosophy here that is something along the lines of the law, spirit of the law is, we kind of personify it, but the law wants people who deserve a recovery to be made whole,
Right.
and that's like my mental constitution here, And there's a lot of ways to skin the cat, a lot of ways to discuss it, but that's what we are trying to do. If there's a remedy for this client and there's a wrong that was done to this client, by virtue of, they had a policy and the policy was violated, or, there's some extra piece of damages that we need to discover, or maybe there's some conduct that would lead to punitive damages, we look at it philosophically as the law says this client is entitled to be made whole. We are just trying to look after the interests of our client, to make them whole, to put them in the spot that they should be. Or if there's a punitive element, we look at it as, this corporation did something that is either willful and wanton, or, grossly negligent, or intentional. And society says, the law says, these are laws that are, either enacted by politicians or committees and validated by government entities. They say that this organization, on behalf of society, should be punished, right?
Yeah.
And that's the position where we find ourselves. And then we hear, the lamentation of the defense, which is, this is a fishing expedition.
Well, I think it goes back to when you're saying trying to make the client whole. It goes back to the comment we made earlier, where it's like, if you don't do, the necessary discovery, you don't dig, fight for what we've been talking about, then you're not making the client whole. And so we're doing a disservice to the client. But also, a lot of the times we see in cases where the defense thinks the case is one thing, but actually the case is totally something different. And that comes from developing the case through the litigation, getting the necessary discovery. Because let's say it's a simple car crash case with a potential punitive element for the corporation, as you just described. Well, if you just don't do the necessary discovery, then it's just a car crash case, and they can get up and say, we're sorry at trial, and then it's like the jury's not going to understand the complexity that's left on the table, because we didn't, hypothetically do what we were supposed to do to get that discovery. But if you do continue and fight, and you get that punitive element, you're able to, well, actually, it's not just a car crash. It's this company knowingly, for example, hypothetically, put some driver out there that shouldn't have been, or they shouldn't have hired them, or they were a culprit in actually injuring our client, or like they had some sort of active part in doing that. And so that's really what this is all about.
A couple points that come to mind are, I've heard this one. This one drives me nuts always. we're fighting for discovery or something like that. And, we get to a spot and, okay, the discovery process is gone. We've gone on to experts. We are now in front of a judge getting ready for a trial or whatever. And then, there's some piece of evidence that, it happens in everybody's case. Maybe it could have been developed a little bit more. Who's the first person to cast that stone? It's the defense attorney, and they say to the judge, well, they should have fought harder to get that piece of evidence. You know what I mean?
Yeah, I can actually think of a case where it's like, well, you agreed to produce it. You still didn't produce it. We filed a bunch of motions. You still didn't produce it. And now you're saying I can't have it? It's like, I don't know about that.
Julian, maybe we can shift the topic to discussing a case that we did a couple of years ago now.
Yeah.
And it is not subject to confidentiality. It's specifically not subject to confidentiality. And it is the Fish versus A to Z trucking.
I think A to Z towing.
A to Z towing.
Yeah.
Fish versus A to Z towing case. Maybe you can tell us about that.
Yeah, that was a case where our client was hit by a commercial vehicle, and basically the way that it developed is she stopped behind several cars, and there's literally nobody behind her except this oncoming tow truck, and he wasn't paying attention. He was on his phone, and he hits her pretty good. I would say about like 50 miles an hour. He careens off the road, and basically the interesting part of that was the initial setup with the crash report. So after a crash, every time there's a crash report written by police for the most part, and the crash report said one thing. Basically, he said wet roads, and he tried to stop and he couldn't because of the wet roads. Well, it was dry outside. There was no rain. And then two, he tells his employer, our client stopped abruptly. He tried to maneuver around, applied his brakes, they locked up, and he couldn't, and he hit her. And then, ironically, there's a dash cam footage in that truck which showed completely different set of facts, where it was like he's on his phone, he's looking down. There's nobody, I would say probably for 10, 15 seconds between him and our client, and he just ended up smashing into her. And then we come to learn at some point later, this is where we were talking about discovery earlier, this is really where the value came in, where we send out our initial discovery, and anytime there's like a commercial driver, there's usually going to be a post-collision drug test or something like that. Or a commercial motor vehicle, there'll be one of those. So we had asked for that, and it was like objection, irrelevant, something, something, something. And I said, well, that's kind of odd. Why wouldn't you just... If most of the time, if it's negative, they're just gonna say, here it is, but they start objecting. It's like, okay, something might be there. And so we fought for that. Turns out the guy had marijuana and cocaine, I believe, in his system. And so that was a good leveraging factor for us. Obviously, our client had a pretty good, serious injury. I would say she had to have a cervical effusion, I believe. And then one of the later parts, we were talking about punitive damages earlier. I don't think it reached this point in the litigation, but I remember we were trying to develop this, was the tow truck company had they were basically actively encouraging this driver to utilize his cell phone while driving their commercial vehicles. And, that's not only against like federal regulations, but this is where you get into corporate complicity and things like this. So that's generally that case in a nutshell from what I recall, but a lot of things there.
So the driver was deaf.
That's right.
And, people who are deaf can drive. Yeah. But for some reason, this company adopted a strange policy of communicating with him instead of using like a CB radio or whatever verbal system that they were using. They would text with him. So this guy was routinely texting while driving his HQ. Like, he was almost required to text while driving, right?
Yeah. And I just thought of something. There was another two things in the corporation that they did. One is, whenever the driver gets hired, they do like usually they'll do a drug test at the beginning just to make sure like they're clean and everything like that. Well, he had failed that initial drug test, and then the employer sent him back again to get retested so he could test negative, so he could hire him. Okay, so like they knew, that this guy was utilizing drugs from the moment he came into their office, and they were like, no, just retest so we can put you on the road. That was one of the things, and the medical certificate. I remember that in order to drive commercial motor vehicles, you have to have a medical certificate. That's part of the federal regulations, and in this case, we kept asking like, where is this? They kept saying there's a medical certificate, and we're like, well, where is it? Like, let us have it so we can. It would make it a non-issue, right? And that's really what we're trying to figure out: is it an issue or is it not? And we chased them around for like a year and a half for this medical certificate. It turns out they didn't have one for the guy, so all of those things together made a really strong case for her. But you wouldn't be able to get there without that year of like probing and doing the process that we go through and utilize here. So that's a difference between a simple rear end crash case versus hey, now the corporations, it's not only a corporation in because of the driver, but it's like the corporation did something as well. You wouldn't know that unless you fought for it.
So 100%, this was a case where, on paper, it initially looked like a rear ender. And then this driver, I feel comfortable saying this, with certainty, fabricated facts and adopted an alternate version of reality to try to mitigate his own responsibility.
Agreed.
That is just factual.
Agree.
And our client was a very nice young lady. She was a waitress. She was trying to provide for her family. And so she comes to us and she doesn't know the value of her case, and just tremendously loyal client. It's the relationship between an attorney and a client is, one of the largest contributing factors to success of the case,
Yep.
And she was a joy to work with, and she gave us I'll say it like gave us the rope and was patient enough to let us go through the discovery process for a protracted, prolonged period of time, because she delayed her result for years. Yep. She suffered. She fought for years to struggle and maintain. Well, we were fighting these discovery battles, and if she didn't give us that time, if she wasn't patient like that, we would have never got the award that we did.
That's true, and a lot of, I would say to the client, to her, it's not only like what we did in terms of discovery, but she had to go and get her treatment, which takes away from time to work, and I believe she had a young family at the time. So that is, it's always, there's always competing interests, right, for the client, because it's like, well, I have to work, I have to provide for my family, but it's like, well, then you're going to live like this for the rest of your life. Well, potentially live with that catastrophic injury for the rest of your life. So it's, you have to juggle that as a client, and it's something that we see all the time. And we have to help guide them through that, where it's like, okay, I understand that, and we have to help sort of maneuver around those interests in tandem with doing what we need to do to, get to the bottom of the actual fact pattern and the liability aspect here. So it's protracted her interest in recovery. She could have took short money, like we talked about at the beginning of the podcast, a year in, half a year in, 2 years in, and it's like, well, look, we're like, just trust us and it'll work. And I would say every time the client just puts immense trust in us, it usually works out in their favor for the best.
Well said. And we're advocates for our clients, but we are also counselors. The type of counseling we do is, very frequently we're dealing with people who haven't been in a situation like this before. They might be going through one of the toughest times in their lives, might have financial issues, might have medical issues, might be intimidated reasonably by the litigation system, and might have any number of hurdles. And we are there to counsel them through those complex and like those impediments to them getting the remedy that they need.
Yeah.
Like you look at that philosophy we were talking about earlier, which is if somebody has been wrong, they're entitled to a remedy. I'm saying it in a different way. It doesn't say it's going to be easy.
That's right.
And we're trying to make it happen, and we're trying to counsel. We're trying to make sure our clients have the tools to get through that very challenging time.
It is often, we see it. It is often the most life-changing event of their life, aside from like maybe a death in the family or something like that, because it's not something that you expect, and then you're thrown into a different world. Most people, like, my world is, they love their work, they love their families. That's their world. I'm not trying to put anyone in a box, but just simple. And here you're put into a whole different set of circumstances that you're unfamiliar with. It could be scary. Most clients don't understand that, or they need guidance in that way. And so it takes us walking them through what matters, what doesn't, making them understand, it sort of helps the information that we give them helps, lessen the nerves or lessen the anxiety of the litigation process. And it allows us to do what we need to do on their behalf too. So all that comes together.
Now, how much did we recover on the case?
I think it was $2.75 million.
Yeah, so I think that the
or
policy...
2.5. It's one of those. I don't remember exactly. It's a $3 million policy.
Yeah, so we did what we're not supposed to do. We gave them a shave off the policy limits.
Yeah.
And
as I recall, this settlement happened right after we filed one of the more tailored complaints, and at that point they wanted to start being serious about trying to resolve the case, because we would have, I think after that we was just ready to do some expert depths or expert discovery and go to trial, and that's the most important thing that we do here, I think, is from inception, not only screening the cases, but it's always an eye towards trial, because that's your ultimate leverage. It's always building the case as if it's going to go to trial, even if it doesn't, because if you don't and you do the alternative, then the trial's not going to go well for you. But that's something we do to help our clients, and I think that's the way you have to do it.
well, my last thought on this topic is our client she did a great job, admirable throughout the entirety of the litigation. And with attorneys like us, we're in a prime spot in our careers. I mean, the way we look at it is we have tens of thousands of clients to help, big cases to work on. Our client has only one shot, right?
Right.
And, there's, when we get into a spot like that where, we could fight and put a lot of extra costs into things, and we might be limited to only $3 million. It's like, it's a little bit of a conundrum, because the client deserved the $3 million, in my opinion, and I think it was obtainable.
It's always the competing interest, right? Or time value money, or all these other considerations that sometimes creep in. But it's as long as we're always counseling the clients appropriately and instructing them of the options, then that's the way it has to be. And sometimes you might get a shave off the policy like that, but it's ultimately in her best interest at that point, given all the other considerations that are on the table or factors on the table at that time. So,
well, the thing is, this is just a sad reality, but insurance companies are a business.
No.
And they know the psychology of plaintiffs very well. They know the psychology of plaintiffs very well. And for many people, if there is a significant amount of money, but it's not the entirety of what they deserve to be made whole. You know, the insurance company is quite adept at putting something that's enticing out there, you know, at a specific time to try to get a bite.
Yeah, we see that very frequently. And it really comes down to the trust built with you and the client for over that period of time up to that point. Because and we see it, if the client trusts us, and they do, then they'd be more willing to withstand that teaser at that point in time, knowing that, hey, we're still fighting, we're still building, and there's a good chance, a very high likelihood that there's going to be more value down the road, even if it's not right at this moment in time. And if they trust you, they're willing to withstand it and go on the journey with you, and it always ends up good for them.
The attorney-client relationship is, you know, it is incredibly important to the outcome of the case and the success of, you know, that the outcome of their endeavor together.
Yeah, and that's really what it is we're representing the client's interests. And so if anyone thinks like, you know, lawyers are not looking out for their clients, they're only looking out for themselves, I would say that's not true. We shoulder your whole life on ourselves so we can get the best result for you. And that's something that we carry every day we're working on your case, or every day we're thinking about, or we're up late at night trying to develop strategies to make your case better. It's like this is all done with the emphasis putting on getting you the best result because we care about you. And that's how we approach every case.
So, you know, maybe one last question before we do some FAQ type stuff.
Okay.
You'll join me for that?
Sure.
How do you feel about your future as a trial attorney? How do you feel about your law firm?
Well, this is the best law firm. I've been here since April 2013. I wouldn't go anywhere else. I've seen it grow. I think we were 3 people at the time, and you had a pretty good case load, but nothing to where it is today. It's like I've seen the different variations over the years or growth, and it's been really wild. Really happy to be on the ride and work on these cases together. Like you said, we work on basically a lot of good ones together, and I would say, you know, as far as our careers, I mean, it's a privilege. It really is to help people. You know, I was thinking back when we talked about when I came into your office in 2013, I was like, oh, I might want to do divorce. It was really targeted towards like helping children, helping you know, what exactly was I trying to find, and you know, I think I've ultimately found it. It's like I can still help kids here. We often do on our med mals or, you know, what have you, or even semi trucks or whatever. But it's all geared towards that, finding that passion and helping, you know, our clients. But the future is brighter than ever, and I'm very excited to keep moving forward. And you know, if you're looking for an attorney, I'm hoping people come to us because, you know, we'll shoulder you all the way.
Okay, so we were just having a nice discussion, and now, Julian, we're going to go over some frequently asked questions. So let's have at it.
Sounds good.
We're going to be joined by Justin Teach and Deanne Fritz, marketing experts and wonder kinds, and just brilliant genius marketers who are going to refrain from repartee at the moment. So let's go.
How do you deal with clients who may be partially at fault for their own accidents?
Illinois has a wonderful solution to this. And in Illinois, if a client is partially at fault, maybe 10%, their award will simply be reduced by 10%, reflecting the extent of their fault. You know, this is great in a situation in Illinois where, you know, hypothetically, there are 3 or 4 cars in a crash. Maybe one defendant is 40% at fault. Another defendant is 40% at fault. One defendant is 10% at fault. Your client is 10% at fault. and your client can still make a recovery. That being said, there are different laws in different states, and I want to make sure I get the terminology right here. But I think that in a state like New York, they have pure comparative negligence, and even if the plaintiff is 99% at fault, they can still make a recovery. Whereas a state like Virginia, and there's a couple more like this, it's kind of a draconian set of laws. If the plaintiff is even 1% at fault, they're completely barred from making recovery, and that's called pure contributory negligence. Now, in Illinois, there is a cap on the amount of negligence that a plaintiff can have had and still make a recovery, and that's 50%. If the plaintiff is more than 50% at fault, they can make no recovery in the state of Illinois. Julian, you have anything else to add?
No, I mean, well said. Actually, it wouldn't actually even come into play until you get to trial or some sort of fact finders making that determination. So if this is something that the client's worried about, it's like you help navigate that throughout the process, but it may not ultimately come to fruition because it's only, at a jury trial or an arbitration or some sort of finality to it. So it's years down the line.
This is a great point. Up until trial, everything is just argument, So you talk to an insurance adjuster, and the adjuster says, well, your client's 25% at fault. And we're like, okay, I'm filing a lawsuit.
It's not going to deter us.
I mean, it's nice that you think that, but, the court is going to be the arbiter of that, and the jury, finder of fact, not the adjuster. Sometimes I think some law firms, maybe members of law firms, get institutionalized, and they start thinking that the insurance company and what they think is actually like the arbiter, and it's really not the case. So yeah, really good point. Just to sum that up, in Illinois, even if you can arguably be said to be partially at fault, you can still make a recovery, and you should still contact an attorney.
What evidence is most powerful in winning a personal injury case?
Well, it really just depends on the facts and which approach you're taking, because as we mentioned a moment ago, there's liability and damages. So we gave the A to Z towing case earlier, where we were talking about liability evidence, but also you have to couple that with what are the actual damages that the client sustained, because you might have, for example, a great liability case, but nominal damages that the client actually sustained, or the flip side, you might have a hard liability case and really severe injury. So it really depends, in short.
To sum it up, for a layperson, I feel comfortable saying the medical bills that you have already incurred, the medical bills that you might be required to undertake in the future, the pain and suffering that you have in the past, pain and suffering in the future, your lost income, past and future, your loss of normal life, past and future, those are your damages. All those elements are incredibly important. Of those, probably medical bills are probably the most important, along with the life care plan or the future medical bills. Aside from that, we're looking at, I would go twofold. Basic negligence, like, was the defendant negligent? And then were there any aggravating circumstances? So did they do something that was particularly bad that, either could give rise to punitive damages, or alternatively, might be something that a jury, finds offensive.
How do insurance companies try to minimize payouts, and how do you counter that?
So insurance companies are very skilled and highly effective statistically at reducing what you have labeled payouts. So if there are 1 million personal injury cases a year, the insurance company successfully minimizes payouts at a massive level. We're talking hundreds and hundreds of thousands of cases where their cases have been minimized due to lack of knowledge, lack of resources, lack of counseling, lack of experience, lack of an attorney, and people take it into their own hands right at the outset, thinking maybe they'll save attorney fees or something like that, and resolve the case too early without having their case fleshed out, without having adequate or appropriate treatment, without having guidance from an attorney about the value and trajectory of their case. That's the first one that comes to mind, but there are others. Julian?
Certainly more. I mean, there's, whether it's reducing the bills, saying the bills aren't worth what they actually read on paper, hiring experts to say, well, those procedures or those treatments that you got weren't actually necessary. They're not actually related to this or related to something in your past that happened 10 years ago. There's all sorts of, or they ultimately try and blame the person who's actually injured for their own injuries to the extent we were talking about comparative negligence earlier. It's one of the tactics that they use.
One quote that always stuck with me is, I was talking to a defense attorney. I don't actually remember who it was, but I've heard, riffs on the same line, which is, it was something like this: as a plaintiff attorney, you have to build the whole case for your client. You have to, from ground up, make sure that your client, has treated appropriately or counsel them about that. You have to collect the medical bills. You have to get the experts. You have to secure the negligence evidence. You have to secure the damages evidence. You have to build the structure. And the defense, they just have to poke holes in it. And you've defined, a lot of different ways that the defense pokes holes in things, and this is a big issue. I mean, we could talk about this just a little bit. In so many of these cases now, our clients just, they see doctors, and doctors are engaged in commerce in the United States, and the doctors generate a bill. We have no say in that bill. Like, the case has no say. The client has no say in that bill. The doctor wishes to be billed for their time and their services and their expertise. As far as I'm concerned, that's reasonable. The defense will retain an expert, billing expert, to look at those bills and say that those bills, they are not usual and customary in amount. So that bill that is $100 should really only be $20. That puts the client in a very challenging spot, because now you have somebody saying all these bills that you have to repay, the bills are too much. So, that creates an imbalance in terms of the recovery the client is able to secure sometimes, and then what the client is actually going to have to repay, because what is the doctor going to do?
Exactly right.
Are the doctors going to look at the billing expert and say, yeah, well, you got a billing expert, my bills are too high? No. The doctor is going to say, well, thank you. It was nice to treat you, and I appreciate you being my patient, but, I'm entitled to full payment. Yeah.
It's a bill for service. Like if you were to do any other type of business in the United States, it's literally the same thing. But we see this quite frequently because it's the way they try to minimize the value on a case. Frequently, we go to bat against these quote-unquote experts, and if we realize what they're doing is actually just trying to, using improper grounds to try and minimize the value, stuff that will never even come into a trial or anything like that. So it's something that could disorient a person who's unfamiliar with the process, but, with people who deal with it quite frequently, we're more experienced in sort of negating that risk and negating that the type of anxiety the client may feel at that time.
I think that, when the billing experts generate their opinions, the ones that we see most frequently have a basis. And the basis is usually not something that is appropriate in courts in the United States. So the basis for reducing the bills in our cases, personal injury cases, they try to backdoor the values from workers' compensation or from Medicare or from Medicaid. Now, these organizations have statutory limits and caps on repayment amounts.
Right.
Whereas, our cases, there is no such applicable limit. So totally inappropriate to use that as a basis. And, I'm thankful for every good judge who sees through those inappropriate grounds for those billing expert opinions.
Yeah, well said. I don't have anything else to add to that.
Deanne?
What is the difference between a minor injury claim and a high-value case?
So, a lot of attorneys, including us, try to hold ourselves out as focusing on catastrophic cases, cases that are complex, cases that have a significant value. And in our firm, if if there's the case where we can say that the the value of the case is going to maybe be $250,000 or more at the beginning, we're going to be able to take that case on, given the dynamic of the firm that we currently have. Not every case that we resolve is $250,000 or more, but there's the aspiration. Maybe we can get involved in that. That comes, because we have only so much capacity to handle cases, and we want to focus on a segment. We want to focus on cases where we can really help people and add value for people. Right?
Right.
Now, there are a subsect of cases, and there are a subsect of attorneys, maybe even the majority, where they will take nearly any case that comes through the door, whether there is property damage involved in the car crash or regardless of the insurance company. And I'm not even disparaging that conduct, people can be seriously injured in a case where there's not much property damage. People can be seriously injured and not get medical treatment.
That's true.
People can get very seriously injured and have no treatment and have no property damage and no insurance. That's a bad mix, but that can happen. And we don't typically get involved in a case like that, if that is the truth of the facts, because it's going to be difficult or impossible to create value for the client. That's really what we need to do. We have, we want to keep our hearts pure. We're trying to get involved and engaged in cases where we can make a meaningful difference to our clients, not just slice off a little bit of a recovery with doing minimal work. I mean, do you have thoughts about that?
Yeah, I mean, it's really like, it's almost like a 1 ER visit versus, and this is just like a hypothetical, but that type of doing that frequently versus, okay, well, I have someone who's seriously injured here, and we can do all the things that we've talked about throughout this podcast to help really change their life. I think that's sort of the stance of that we're talking about, is building it up versus just getting the bill, sending it in, and doing that 1,000 times.
This is the challenge, though, and this is like always it's like an ethical conundrum, because we're so focused on segment and focusing on cases where we can really make a difference for people. This is why firms who have who can take cases that are worth $1,000 or $2,000 or maybe are worth $1,000, they are performing a service to society. Because let's say somebody's injured and they just go to the ER, and it's a case involving a substandard insurance company. That's going to be a very challenging case, to recover, $3,000, you might literally spend, or utilize $10,000 worth of resources. Mm-hmm. And, that is something that the insurance companies take advantage of. People who are in that range of crashes where there's a, just minimal treatment, and maybe a substandard insurance company, the insurers, they profit off of that.
We see that, and we see also, getting them to sign a release like right after the crash or something like that, where client doesn't know, or potential client doesn't know, what the significance of that is at the time, because maybe they're still feeling the adrenaline from the crash, or they're not fully understanding the significance of their injuries at that time, and then a couple days go by and they're like, oh, I'm hurt, and they have to worry about this release that they sign or something like that. We see that quite frequently too.
To be candid, I view one of the roles that the law firm performs, especially as we reach more people, as performing a semi-societal function by providing education. In the even if it's just a nudge, so that people are more well advised at the early stages of the case. They are more open to the concept of getting some counseling from an attorney. And, for individuals who, have a very challenging set of circumstances at the outset of their case, maybe a substandard case, insurance company, maybe limited property damage if it's a car crash case, or maybe, a slip and fall where there's not a lot of evidence. Maybe they didn't take photos, or maybe there's a week or something like a gap between when the occurrence happened and their treatment. They still deserve a remedy. It's like they were wronged. It's just there's a gap between what the law is going to be able to do for them and the remedy that they deserve. And I would love to create a scenario where we could help more people who have challenging sets of facts, even if it was, not just profit motivated, so we can help these people. And, I'm not here to make high volume firms sound like they're in the business of charity, but I kind of respect any firm that's out there keeping insurance companies correct and, making sure that good people are receiving remedies when they've been wrong.
Absolutely.
So anything else to add to that?
No.
Deanne?
How important is medical documentation, and what should clients be doing during treatment?
Medical documentation is definitely one of the top 2 or 3 factors that leads to good outcomes in personal injury cases. Any word that a person says to their physician, to their nurse, can be recorded, documented, and it can come back to haunt them. Additionally, if a person does not speak English well and some words come out that can be construed a certain way, that can be very damaging to a case. Additionally, and this is just a fact, sometimes medical personnel, and that includes physical therapists, physical therapy techs, that includes nurses, that includes PAs, that includes NPs, that includes RTs, that includes doctors, it includes residents. They can just write stuff down that's not fully accurate. And that can also create a challenging set of circumstances. We spend a lot of time working to massage those facts and to, put together and compare what our clients believe actually happened versus what the records actually say. And, it's always best when everything matches up great. The insurance company is specifically looking for discrepancies to exploit to minimize the value of those cases.
Yeah, I would say, along those lines, it's like blowing a statement out of proportion or taking a statement out of context is one of the biggest, quote unquote, defenses that are utilized against plaintiffs in our cases, where they're trying to say, oh well, this statement means like you were injured, a new injury, and now all of your pain and suffering and everything you've been dealing with for 2 years is related to this, instead of this significant crash or this significant surgery that you had that went wrong, and it's like, it's not, but that is what they will do to try and fight us on a case.
I have an anecdote that I always use with clients. It's like the one I use because it was the most absurd. I had a client that was hit by a utility truck at high speed, and on one of the major thoroughfares in Chicago. The client was, injured, really injured, and she had some other conditions too, like carpal tunnel, something like that. And so the defense kept on trying to blame all these like ridiculous symptoms on the carpal tunnel, which was silly. But then the client made a statement to one of her physicians. She said something like, I picked up a laptop computer and then I felt ridiculous symptoms. Like it was kind of vague, the language. It wasn't like it was caused by the laptop. The way I interpreted it is like it provoked them, or she felt them at that time. But the ridiculous symptoms, it was clear, and thousands of pages of records were from the truck. So the defense's argument is now, well, the ridiculous symptoms are from when she lifted the laptop, which was just, amazing. I use that anecdote to talk to clients, and it sounds like almost absurd or, just far-fetched. That actually happened. I don't know if you remember that one. That might have been before your time.
It might have been. I'm not familiar with that one in particular, but it is like it is important for the clients to, obviously tell the truth to your providers. No one's telling you to say anything other than the truth. But at the same time, you have to be careful in the way that you convey certain information, because it could be misstrued. It's like the game of what is that cup phone or whatever it is, where it's like telephone. You say one thing and then they hear it a different way and they write it a different way, and then now it's the whole case is trying to be made about something that it isn't. And so it's trying to convey it as accurately as possible, but be truthful in the same sense.
It's a funny irony. It's like if you go to a jury and you say, hey, this is a red herring. Now somehow they don't think it's a red herring. Yeah?
They're like, well, you're telling me it's a red herring, so it's actually important.
Yeah. It's funny, how things work like that. But, basically the entirety of my career, I've always felt like that move was baloney. So, Deanne, do we have one or two more?
Yes. What happens if someone doesn't go to the doctor right away after an accident?
Well, if somebody doesn't go to the physician within just a few days of their occurrence, that could be a doctor, it could be an urgent care, it could be their primary care doctor, it could be going to see their specialist, they're going to have a very challenging time making the argument that injuries and symptoms that are documented, 1 week or more later for the first time are related to the crash. That's going to really present some hurdles to somebody bringing a case and having a significant case. It's going to potentially even be the death knell to the case. We get calls at our law firm, like dozens a week, where somebody was involved in a truck crash. They never had any treatment, and now 6 months later, they want to get treatment for the first time. Or, somebody is in a car crash and they don't get any treatment for a month. Typically, we look at those cases as sad situations where we can't get involved. So, Julian?
Yeah, and it's all about perception, because, no one's discounting the fact that you may very well have been in pain for 6 months of time, and maybe life encountered you and you just chose not to go to the physician given the circumstances of your life. But you have to convey this all to your peers at a trial, and that's something that a lot of people have a hard time dealing with, where it's like, look, if you're really as hurt as you say you are, how come you didn't go to the doctor for 6 months, or as your example?
Yeah, it's sad because a person can be in significant pain, they can have problems, but not go to the doctor. Some people don't like going to the doctor. Some people are scared of going to the doctor. Some people are, maybe they're financially pressed and they don't want to run up bills. That's a perception people have. Yep. But in this society that we live in, if you or a family member is involved in a crash and you fail to go to a doctor, physician, or medical facility within about 7 days, it will harm your case. Last FAQ, Deanne, can you hit us with one?
Can you reopen a case and get more compensation after a settlement?
In personal injury cases, there is no mechanism by statute to reopen a case after it has been settled. And, for most people, the vast majority of the time, if there is a settlement or, that somebody has injuries and they've received treatment and they settle the case, there is no further recourse. That is it. Case is done. That being said, there are some exceptions, and I have not actually personally been involved in a deal like this. They're exceptionally rare, and insurance companies, they don't want the long tail exposure. But there are situations where an agreement can be made between an injured party and an insurance company where future treatment might be covered up until a certain amount. We see this a lot in those settlements that an insurance company will sort of foist upon an injured party at the very beginning of the case, and they'll send a release and it'll say, well, you were in a crash, here is a settlement for $2,000 and we will pay up to $10,000 in future medical treatment. And that seems like it might be compelling to somebody who's totally inexperienced, but that's when I see that context. It's like not in a beneficial deal. In workers' compensation, cases can be left open, longer, with the anticipation of future treatment, or maybe that can even be worked into a workers' compensation agreement. But in personal injury cases in Illinois, it is typically not the case that treatment will be open, or you can have treatment that would be attributed to the case after the case is settled or has gone to verdict.
Yeah, I would agree with that. I think one of the things that you were talking about was some of the releases that are done at the beginning of the case, and sometimes what the insurance company will do is say, all right, here's a general release. Here, it applies to both your injuries and your property damage, but the payment will only be for like one or the other, and then you have a mechanism through the courts to fight that, but it's exceedingly rare, and so that's all I have to add to that.
All right, so that, if I dare say, that'll conclude our podcast for today. Julian, thank you very much.
Thanks for having me.
And special thanks once again to Justin Teach and Deanne Fritz. So I hope that you enjoy this podcast, and thank you, everybody.